You ready? Good morning, everyone. I'd like to call to order the Spokane County Planning Commission. Today is October the 17th, 9 a.m. Thank you for being here. The public may participate in person or remotely by utilizing our web link and telephone conference link *9 to raise hand, *6 to speak. Individuals are limited to 1 3-minute comment period for any item. Please keep your comments specific to the current agenda item. Chat is not supported. Our first order of business is to introduce ourselves.
Melissa Wittstrup.
Lonnie Edwards.
Wayne Brokaw.
Pete Rayner.
Stephen Pohl. Our members, Logan Camporeale will be here a little later, and so will Mr. Clyde Haase. So we expect to have a full complement of commissioners here. Thank you for your confidence. All right. First thing we talk about is the open forum. This is the part of the agenda where if anyone in the county would like to come and address the commission that are not on this agenda that we're looking at today. Does anyone like to come and say something that is not on this agenda? Now would be the time. Anyone raise your hand? No, nothing. Okay. Let's move on. I'll turn it over to Scott.
Thank you, Mr. Chairman. We are asking your, asking your indulgence to flip the 2 public hearing items that we have on your agenda and consider the utility scale wind power item first. And if the commission doesn't object, we'll move right into that.
Without objection, so ordered. Scott?
So as you recall, and we're going to go through a fairly detailed summary of what the staff is considering for creating this new code. We're going to look at some of the technical issues about this, some of the policy issues, and then we will open this for public hearing. There are really these 5 basic objectives or goals that were driving the creation of this code. And you can see they're not in a particular order, but they really almost kind of go from top to bottom. Protecting ag businesses and cropland, in addition to being good economic policy for Spokane County, it is also mandated by the Growth Management Act that agricultural lands should not be taken out of production. Aviation facilities, the airports, certainly Spokane International and Fairchild, but small airports are taken into account as well. There is a goal of renewable energy. And so the governor has made that clear for the state. And we're looking at that. We will be meeting with Avista later this fall to talk about some of the details on how they would integrate into any future wind or solar operation. And then we're certainly aware that one of the potential benefits to individual landowners is this can provide a revenue stream that might help offset the always ups and downs of the agricultural markets. And of course, safety and protection of wildlife, notably in our southern third of our county is the Turnbill National Wildlife Refuge. That brings up kind of a challenge for windmills being around a flight pattern. So there we go. So in looking at the first goal, a couple of possible policies, again, discourage the permanent conversion and then don't locate non-ag uses in ag lands. Possible draft code could have something that, these elements, essentially the first one's talking about prime ag soils defined by USDA rather than a zoning criteria, but an ag protection plan and then the project, all of these will be conditional uses. So the hearing examiner will look at the various elements that go into the code, decide if the application meets them, and if conditions are met to ensure that they are in fact met. For the airports, just simply policies that are fairly obvious, incompatible with Fairchild and located away from Spokane International. Renewable energy is a policy to ensure that we are supporting renewable energy, and this code is looking at where it can take place in addition to protecting the other various layers that are mandated by GMA and by Spokane County's own economics. And again, you can see that in this slide. And then wildlife, we're looking at boundaries, and we'll talk about that in a little bit, setbacks and things for these facilities from Turnbull, from designated wildlife corridors that are mapped and part of our comprehensive plan. And ultimately, we'll be seeing what we call a map that'll show where these things are generally allowed. So the permitting process for this is, at the moment in the state, is a three-part process. The reason we're going through this exercise is to create a local process so that landowners and energy companies have a point of contact here, most local to the lands that are being proposed. Currently, the state also has the Energy Facility Site Evaluation Council, known as FSEC. That is a multi-agency body that can take direct applications, and it has the ability to preempt local codes. So if the applicant were to go in that direction, at the moment, we would get a seat at that negotiating table, but it would be a state function that would not be required to observe local codes. Again, the reason we're trying to create the code is to have something to have at that table, even if we're negotiating at the state level. And the Department of Ecology also has a parallel process that focuses on ecological impacts and will create an environmental impact statement. So while this is hard to read on the screen, these are the three processes, with ecology on the left, FSEC in the middle, and a local process on the right. And you can look at the various coordinating efforts through that, whether we require pre-application process, who are the decision makers, who takes the SEPA lead, for example. So we're putting this together to provide you and ultimately the board with a series of options that are going to be at least compatible with state laws. So what we've looked at is these things they're kind of broad categories of what we see are best practices. We have looked at our peer counties in the state. We have looked at counties that are deeply into providing wind energy, Whitman County, Benton County, others. Staff has also looked nationally at projects around the country and even internationally to glean what really is the best practice for these. And you can see the kind of metrics here: safety, how the turbines change over time, setbacks, big issue there, environmental protection, visual resources, aviation safety, and decommissioning, often not really thought of in our process, but we've seen that, and we'll talk about it later, you need a decommissioning plan when you start. And part of that would be analogous to what we work with our colleagues at DNR on mining and mineral extraction. When you get zoning and a DNR permit to ultimately start mining and minerals, you must have a reclamation plan on file from the very beginning. This is kind of that same philosophy. It's like, how is this going to end in 20 years or 30 years? So public safety, some of them are fairly obvious, but a fire protection plan, physical monitoring of the site, emergency response. They may seem obvious, but unless you have them in that plan, you don't necessarily think of them. Turbines height. You can see here, and we've got some charts, between 98 and 23, the turbines have gotten 73% larger. Very simply, a larger turbine generates more energy. So it makes some sense. And you can see that graphic here from the early 2000s up to 2020, and the offshore versions of that being even considerably higher. And so here what you can see is roughly the diameter of the rotor versus the capacity in megawatts, going from a little over 1 to almost 3 1/4 in that period of time. So more towers, bigger rotors, generating more power. This is kind of a composite of that, but again, those averages, the largest in 2010 was 380, and now the average is 430. And so those affect sighting distances. They affect all sorts of physical metrics on how these work on the ground. Our best practices, I hope it doesn't sound counterintuitive, but we're finding that we should not be actually limiting the height of the towers. We should let the market figure that out, because that will help determine, what's going to be more efficient for renewable energy. But you need, standards and a few things for some basic parameters. And the setbacks are, what we need are really non-waivable occupied building setbacks. So there is that safety factor, setbacks from the boundaries of communities and setbacks from non-participating owners. That's a harder thing to do. Of course, we can map some of those first ones. You can't map the property out because you just don't know who's participating yet and who's not participating. So the best practice for building setbacks there's several. One is simply 1,000 foot. One is 1.5 times the height of the tower. And then the blade height, the tower and the blade height is there. 1.1 times that is what Adams County did. Whitman County did 1. And in a recent case, FSEC has created a 2,500 foot setback. So there's some variance in what's a standard here in Washington State. And you can see these setbacks. We put these on, that's the FSEC case that used that created that 2,500 foot. And then the 4 times setback, or 4 times the height of the tower, was in the Washington Supreme Court in a decision on residents opposing the Kittitas County towers themselves. So yet another standard, which is really ambitious. If you've got 1.5 times the height of the tower, you've got a certain density. If that increases to 4 times in any given area, you've reduced the number of towers by probably a factor of 8 or even 16 by how that may happen. Incorporated communities, 1,000 to 1,200 meters. And to put that in our terms, that's about 7 times the turbine height. And then, of course, the FSEC, the 4 times the turbine height is what was in court. Property lines, again, back to 1.1 to 1.25 times the turbine height. And again, we're noting that's variable really all the way up to 4 times. But a 4 times practice from property lines is probably unrealistic. Most parcels, even in our large tract ag or southern part of the county, are not big enough to support support the energy generation at scale. If there's a 4 times setback from adjacent non-participating property owners, it would be hopscotched all over the place. So that may just not simply be reasonable. In the natural environment, we're looking at Department of Fish and Wildlife is producing guidelines. We're studying those, and if they're accepted, they'll provide a good standard by reference that we would anticipate adding to our code. For visual resources, we've looked at the American Planning Association and how that can happen, and they talk about what color they're painted, how they're lighted, and how they don't become billboards in some way. So noise and sound, oftentimes neglected if you don't drive by them or live near them, but they do make noise. It's constant noise at times. And so, what are those standards and can they be mitigated? And then this one, which we, again, you don't think about unless you're on the opposite side of the sun from a propeller. There's that flicker effect. And if that's your property, you're subject to that, as long as the sun is going in that path across the process. So the idea is there a limit to that? Or do you set this back in some way to minimize that approach? Aviation safety is fairly straightforward. It's more of a distance and making sure turbine installations are not in established flight patterns or inbound or outbound routes. And so here's some new information that you haven't seen from last time. This is an kind of well, it is a wind map. And what you can see in down by Walla Walla is that darker burnt orange, red, also by Richland up into the Yakima Valley. Those are areas that have quite a lot of wind power today. And this is why. That's where the average winds are sufficient to do that. As you see Spokane and can imagine Spokane County around that, down in the Palouse in our large tract ag area is kind of that next one down of potential wind. So it's not in a sense in the prime country, but it is in what appears to be viable country for wind power. And this is a little more direct from our county itself. And of course, these are abstract maps based on average wind calculated by the Weather Service over time. But you can see at the lower part of the county, we have the best opportunity for do that, and then in the western part as well. Here are some things from wildlife protection, both in the migratory birds down to endangered species, about protections, permits, and penalties. Again, hard to read for probably those at home, but it's an accepted source that we would look to for guidance as we create a code to do this. And it's generally here. It's pretty simple. Forbids harm to wildlife. Endangered Species Act does frankly allow for some mortality, but it has to be mitigated and it has to be reasonable. And we discovered that even bats are protected under federal law from energy generation. Then decommissioning, created a plan, their disposal, making sure that the county is not held responsible for making that happen using bonds or something, and then required to disassemble and remove after a certain amount of time, just basic parts of a decommissioning plan. Put all of those things together, and this is a map from the East Coast, but it becomes a constraint map. Where can you build, where can you not build based on these codes? We are working on preparing this right now. It is, as you might imagine, complicated, and we don't have something for you today, but we're going to be putting that together for the briefing we will share with the Board of County Commissioners on November 4th. So some other impacts that don't necessarily relate to the physical generation of this are tax impacts. We've talked about providing a revenue source for landowners that are in agriculture to help offset the seasonal variances of crops. There are also impacts on local governments, and counties generally are that, because as you might imagine, these are always or nearly always in unincorporated parts of various counties. The challenge we've discovered, and this is with our colleagues at the Association of Counties, is under Washington law, these wind facilities are considered personal property, not real property. And so therefore they depreciate, or they're allowed to depreciate. That depreciation means the tax value to property tax goes down as those depreciate. And so there's a diminishing return on local revenues for that. And then the challenge is if a county government sets its rates based on the taxes, and the property tax from this goes down 15, 20, 30%, that county rate is still in place, and that forces all of the other taxpayers to fill the gap, to fill the delta. And so there's a huge public policy issue on how do you structure a tax policy that takes into account a diminishing source of revenue from these particular pieces. So one of the things is looking at a number of possible sources from, and here's a couple of descriptions. Simply a tax per unit, a nameplate tax, a production tax, or an income generation fee of some kind. And also, you may have caught it on the last slide, something that's used in development fairly frequently is a payment in lieu of taxes, to simply negotiate a municipal payment without using a tax structure to do that. All of those are potential tools that the county could could offer. And so with that, Mr. Chairman, I will stop, and you're welcome to renew the public hearing and take any testimony available.
Yes, thank you very much, Scott. I'd like to open the public hearing for ZTA 04-24. Any preliminary comments from the commission before we open up to the? We have a number of people who would like to testify. Thank you for coming and producing these beautiful yellow slips here. 04-24. So Michael Chambers, are you available to speak? Thank you for being here.
Good morning.
Morning.
Michael Chambers, 33424 South Houck Avenue, Cheney, Washington.
Thank you.
My question this morning begins at the beginning of this presentation that we just received. In the planning process, it discusses the 5 points that were specialized as we needed to target points, I suppose. And the one thing that's missing from there is personal property rights. I mean, we listed all kinds of stuff, and it does address personal property rights in the meat of the document, but in the beginning of the actual points, it doesn't mention personal property rights. And I thought that was pretty important because the residents that live out in the communities that these will be placed also have a say and a right to be heard and see what the impacts would be. And so by putting us on that 5 list, then it weighs into the future discussion because it's a primary target. So that's really all I have to say.
Thank you.
Thank you.
Matt Showalter, please. These are in no particular order. I'm just going through them, so
Fair enough.
sorry.
Thank you. Hi, everyone. My name is Matt Showalter, and my family owns and operates a 6th generation cattle ranch outside of Cheney. And we've leased 2,200 acres to Cordelio for their wind energy project. Now, today I want to specifically talk about setbacks as they pertain to wildlife areas, state parks, and wildlife refuges. So to do that, let's take a look at Turnbull's conservation plan map here. So this area inside the green boundary is property that's owned by Turnbull, and the current draft has setbacks relative to this much larger blue boundary here that they call their stewardship area.
Can you try to speak into the microphone?
Yeah, sorry, maybe you could pull a little closer here. This much larger blue boundary called the stewardship area, but clearly they are not the stewards of this land because this is all privately held. So the other term used is the authorized acquisition boundary, which means that Turnbull wants to own all of this land, but they don't for various reasons. In the case of my family's ranch here, the reason is it's not for sale. We have owned and operated that ranch since the 1880s and don't want to change that anytime soon. Now, what the current draft does is it essentially takes our property development rights and gives them to Turnbull, presumably for the greater good of the American public. And the entire value of that wind contract gets ripped away exclusively at the cost of my family. Now, I'd like to mention that the U.S. Constitution, the 5th Amendment, has what's called the Takings Clause that says, nor shall private property be taken for public use without just compensation. Further clarified by the Supreme Court in 1960, the Takings Clause was designed to bar government from forcing some people alone to bear public burdens, which, in all fairness and justice, should be borne by the public as a whole. So the point in this is that the draft as written currently is unconstitutional because there has been no just compensation, or any compensation for that matter. Now, this could all be easily solved. The problem originates because of an arbitrary line here that has no legal basis to it. So it could be solved by using actual property boundaries. And really a logical setback would be 1.1 times the turbine height. And then you use the wildlife study and the data from it to make an informed decision on if there needs to be exceptions to that rule. And if so, Turnbull will have to provide just compensation for these property development rights from these landowners. Because right now it's asking essentially that all these small farmers and ranchers pay the entire cost for the benefit of Turnbull. Thank you for your time.
Thank you. Nelson Cordell?
Good morning.
Good morning, sir.
My name is Nelson Cordell. I live at 20116 West Sterling Road in Cheney. I'm talking about the wind turbine zoning. I am a fourth generation cattle rancher to manage our family farm. Our land has been managed by my family for over 100 years. Much of this ground is located within the Turnbull stewardship boundary. My family and I have leased our property to Cordelia Power for their energy project. Our family decided that this was a good fit for our ranch and the community around us. It will provide us with additional income streams and provide new jobs and income for the Cheney community, providing long-term benefits for everyone. This project has the power to positively impact our entire county while providing better energy security. The way things are, many farm families cannot make ends meet. The price of our farm commodities are below break-even prices now. Our crop inputs, such as fuel, repair parts, and even new equipment, are heavily inflated. This project is a lifeline that'll give us the flexibility we need to manage our budgets and keep our farm operational and locally owned. I am here today to express my concerns about the current draft regulations that require a 4x turbine height setback from lands located within the Turnbull stewardship area, Washington State parks, and wildlife boundaries. I urge the commission to reconsider this setback requirement for the following reasons. The Turnbull boundary is located on my east boundary of our ranch for 2 miles, on my north boundary for 1 mile, and I am blessed with 7 miles of the Columbia Plateau Trail running through the middle of my ranch. These excessive setbacks make it impossible to site a wind turbine on my ranch and our family enjoy the benefits it could bring to us. So where's the science in all this? All this is private ground, not owned by Turnbull. We do not have control of our land. They do not have control of our land, but want to legislate what we can and can't do at our expense. Remember that the stewardship area is really a federal designation for potential land acquisition to expand Turnbull boundaries from approximately 23,000 acres as of 2020 information, up to an additional 32,640 acres. Currently, 7% or about 3,300 acres is open to public use. The rest is closed to the public, except for permits. We need zoning regulations that do not infringe on citizen properties, rights, or limits. Thank you.
Thank you, Mr. Cordell. Jackson Morgan. Thank you.
Good morning again, Mr. Chair, Commissioners. My name is Jackson Morgan. I'm a Spokane County resident, and I'm here today representing Tenaska and Cordelia Power. I want to begin by commending Scott Chesney, Josh Warwick, and this entire commission for the thoughtful, diligent work that it's been put into this process. From my experience as a wind energy developer, I've seen many counties tackle the complexities of drafting these ordinances, and I genuinely appreciate the balanced approach you've taken here and look forward to working directly with Spokane County as these projects develop. While I see that balanced approach reflected throughout much of the updated draft ordinance, there is one area where I believe it's imbalanced, and at this point, it's probably no surprise. It's the 4 times tip height setback from the Turnbull Wildlife Stewardship Area. I'd like to outline 3 key reasons why I believe this provision needs to be reconsidered. As you've heard before, first, the term stewardship boundary is a misnomer. The areas from which this setback is measured is actually over 32,000 acres of private property, over which Turnbull Wildlife Refuge holds no title or legal authority. The boundary merely represents the limit to which the federal government has authorized Turnbull to expand by purchasing land from private owners at fair market value. To base such a restrictive setback on this notional boundary line, property that remains in the hands of private citizens, is an overreach that prioritizes the refuge's aspirational growth over the rights of landowners to pursue the highest and best economical use of their lands. Second, the proposed setback fails to adequately prioritize property rights. More than 20,000 acres of privately owned land within the described stewardship boundary have been committed to wind energy development by Spokane County landowners. These are local farmers and ranchers who stand to benefit economically from this development, especially as their margins grow tighter each year. For context, $100 million is a conservative estimate of the lease payments that will accrue to the landowners within the property inside of the stewardship boundary over the course of the life of the project. We've heard this commission acknowledge the economic benefits of wind energy development that it brings to the community. Lastly, seeing that my time is running down, the blanket 4 times turbine tip height setback is excessive, particularly when considering that the draft ordinance already mandates a more effective, environmentally focused approach. Section R on page 5 of the current draft outlines a rigorous, data-driven pre-construction process requiring comprehensive environmental impact studies, including raptor nest surveys and migration route analyses, all conducted by independent third-party experts over several years. These detailed assessments will be made public and will guide WDFW in making informed recommendations about where wind energy development can coexist with local ecosystems. This science-based approach offers a far more balanced, nuanced method for protecting wildlife while respecting the property rights of landowners. Allowing environmental data to shape decisions avoids the imposition of arbitrary setbacks that not only threaten the economic feasibility of wind projects, but also unfairly burden landowners without delivering significant additional environmental protection. Thank you for your time.
Thank you. Is there anyone online that has their hand raised? Ron, no. Commissioners? Scott? Rebuttals, comments, observations?
No, all very good comments.
Oh. Is this for the wind farm?
No.
No. Yeah. Thank you, though.
No, all reasonable comments.
Do you have a, wait a minute, hold on. Is this, are you for the wind farm? Wind farm?
Yeah,
Come on down.
I didn't plan on speaking. I just.
Well, you're stuck now.
Okay.
Come on down.
I understand. I just want to talk briefly. 6th generation farm in the southern Palouse. I just thought I'd touch on the farmland briefly.
Will you put your name for the record?
Carrie Jansen.
Thank you. Thank you.
Yeah.
Go ahead.
And we farm in Latah, Washington, 6 generations on the ground. I've been approached on our 3rd wind lease through the years. If you look on your Spokane County map there's some red right in there on the high mountain range, you know, it's pretty high wind energy. But just want to comment to anybody here, if there's anybody needs to talk to anybody further, I'm open down the road as far as the farmland part. Anyway, like I say, we're in favor of the wind farms. We're on our 3rd, been approached by our, you know, the 3rd one. We've done it through the years on that area. See no problems with farmland. We're, you know, generational farms to where we're passing our farmland on to 2nd or 5th and 6th generations now. So we're in favor of the wind turbines. It's just what I want to say, and I'm open to anybody down the road if they want to comment further on that part of the project. I would talk to them at any time.
Thank you.
Thank you.
Melissa?
Thank you. I do have a few questions, and I just want to harken back to the comments that we received earlier about the 5th Amendment. And I'm just checking myself because it's been a while since I read the whole thing through. Is it, as long as they're not precluding any economic benefit or creating an undue hardship in achieving economic benefit, that's when we have a taking? Is that, am I off base here? I just want to check.
A little. There's an outright acquisition of property that requires just compensation. And then in which case the property is acquired through a negotiation or through eminent domain. But what's also being talked about, it's not being talked about here, what's being referred to as a regulatory taking, which is to say, I have this opportunity to make this amount of money with this project, and you're precluding me from that with local regulations. Therefore, that's a regulatory taking. I can't interpret that today. I'm not a lawyer, but that's the presumption of the argument is we're not trying to acquire land for this, but we're prohibiting its full economic, or as has been called, highest and best use, by saying we're regulating against using it for this tool.
Okay, so I just want to follow on that. Thank you for the clarification. So this is not a right that's currently in existence. It's not in the bundle of sticks that go with the properties currently?
No, there have been several court cases, both Supreme Court and state court cases that have found regulatory takings exist. So it is a well-defined legal principle at this point.
Even though Spokane County doesn't have
Oh, there's nothing
a
today. No,
wind farm.
no. There's nothing in Spokane
Regulation.
County today. It's why we're producing this code, is to say, here are the regulatory rules on where you can and cannot build. The setbacks and the other things that have been talked about. Again, we have no recommendation for you. We're here to gather, information from the public and from science. And as we've noted, the 4 times sort of came out of the blue in terms of a decision that we weren't even considering last time. We will be putting that together with best available science. And so the point specifically related to Turnbull is their stewardship area doesn't have legal status. It's an aspirational goal by the federal government. Well, we would take that into account. Everything we talked about up before was based on property ownership, setbacks from non-participating property owners. But the stewardship area is owned by private farmers. And so if they choose to participate, unless there was a best available science that had that, and that might very well trigger a regulatory taking. If that's the case, then that would either be something the county board would consider, or it would fall perhaps to the federal government to say, we're protecting this because of Turnbull, therefore you have to be part of this regulatory taking settlement. Again, I don't want to get into that path because we don't have a basis for that yet. Gathering this testimony gives us the chance to understand what those concerns are and take them into account as we refine this for, its next public unveiling.
Okay, and I just want to make sure, I don't want to assume, there is a legal precedent for the 4 times height. Now, I mean, currently, there's a court decision.
No, it came from FSEC. It came from the state regulatory body. They made a determination in a case to impose that. We have to go back and dissect that a little bit. It's like, how did you reach that conclusion? What was your best available science to reach that conclusion? And if it's a very narrow, tailored rationale, that may not make any sense for Spokane County. Because I'm sorry, not to be repetitive, but what we're trying to produce is an ordinance that does in fact provide a revenue stream for our farmers and ranchers, because we know how important that is to keep our ag economy whole. So we're not looking at this as a purely regulatory body. We're looking at this as, how do we help grow our rural economy and what makes sense? Because there's always that trade-off. That's what the planning and zoning is about. How do you get highest and best use here and protect neighboring landowners from that use? And so that's the balance we're striving for.
Okay. I mean, I get that rationale and appreciate like I said, appreciate the clarification. So this is going to the county commissioners November 4th for a
Discussion.
hearing, discussion?
Yeah, we last talked to them, well, at least a couple of months ago. And we outlined where we'd be going with the planning commission, a series of public hearings, gathering information. We're going to go back to them on the 4th and share with them what we've learned and your comments and the comments from the public, and get their direction on how they want to proceed. I anticipate after that, we would be wanting to go out and engage with the landowners, as the gentleman offered. Yeah, we will go talk to the individuals on what's going on. Bring back something for another public hearing after the 1st of the year, perhaps January sometime, and go back to the board perhaps in February.
Okay, and then I just want to make sure that I picked up on this correctly. That taxation piece of it, they are allowed to take depreciation. So over time that it'll depreciate the asset and that will get redistributed to the rest of the taxpayers in Spokane County.
That's what the Association of Counties is finding.
Okay, because we already have like significant tax burden. So I just want to make sure
Right.
that I understand
Right.
that.
And
as
the
we-
slide of
as we go
alternate,
forward.
I'm sorry, the slide of alternate revenue sources reflected the fact that municipalities are allowed to increase their property tax by 1% a year without a vote of the public. If that 1% a year can't possibly keep up with the depreciation value that drops the property tax on the wind farms. And so those other alternate sources could be explored as a way to keep the county's budget whole in the face of that depreciating revenue. So it's not a total zero or a total loss. It's like if this is going down, but our budget line is staying constant, what sources do we have to fill that delta gap? And are they viable?
Okay, and I just want to be sure that I understand. There may be other zoning regulations that would allow other uses that would help support the rural economy, like, I don't know, development, residential uses. I'm not sure. I'm just trying to see what's the whole picture here.
Well, the whole picture is what we're going to start talking with you about at our next meeting, which is the Comprehensive Plan 2026 update. We are very much going to be talking to our farmers and ranchers on what do you need? That and we're limited. We can't just have a wish list of new revenue sources because the Growth Management Act does in fact protect agriculture. But we want to look at, are there alternate things that the county can put in its development code that provide a chance for increased revenue beyond renewable energy? So yeah, we will be looking at least exploring what else we can do in our rural lands.
Do you have a map handy, or maybe we'll see it next time, of where the prime ag lands are? Because to the south of us, we have some pretty darn fine soils.
We do. I don't have an easy way to bring it up.
That's fine.
If everybody here wanted to come up to my office, I've got one on the wall, but we created that map because I was curious as to where they are. We have our zoning map, large tract ag, small tract ag, but I wanted to see how they overlaid with the USDA soils. And for the most part, they do, not surprisingly. But yes, the Palouse is a huge part of prime ag. And that map has two other categories: prime ag if irrigated and prime ag if drained. And if you take all of those combined, there's really quite a lot in the southern half of the county that would fit the prime ag discussion.
Okay, and I just want to make sure. Can't develop in wetlands. So where there are wetlands that are existing.
Right.
Which
a different-
happen out in the Cheney area.
It's a different part of our code, but
Sure.
that's in the critical areas part of the code. And
Right.
that already has prohibitions against development in or within buffer zones of critical areas. That would apply to this today.
And those weren't considered regulatory taking.
No.
Okay. Thank you.
I've been at this for quite a long time, and this is probably the single element that I felt like I was most out of my zone of information. But I have a question. You said we're looking at doing this process so that we have a seat at the table. And my question is, if we don't do this process, where does it leave these gentlemen who just were concerned that they were being left out of an economic opportunity? In other words, if Spokane County doesn't adopt regulation, have we opened the door for them that in the direction we're going? And I'm not saying we're going there. So anyways, just.
Yes. The reason we're here is the Spokane County Code is essentially silent on renewable energy, solar or wind. We're way past being current on this. The county should have anticipated this, 10 years ago at least. However, that's where we're here today. The state licensing and permitting procedure exists today. So the energy companies that are talking to our landowners if the county offers no path for permitting, they can go to the state and open an application and get started. What that means though is while Spokane County still has a seat at that table, we have nothing to fall back on and say, here's what the public policy by our commissioners thinks is good and bad.
Jackson, if I could get your business card before you leave, I appreciate it. Because as I travel throughout here and into Central Oregon as well, there's a lot of wind farms, and I know a lot of the ranchers from Cheney all the way down. And so it's really is a priority for me that we get this right and we make sure we're doing what's right for our private owners. So I appreciate it. Thank you.
Is anyone online? Do we miss anybody in the audience that wanted to speak on this topic? Scott, I have a question for you. This is characterized as a public hearing. This can either be opened or closed. What do we do here?
No, we're simply asking you to leave it open for the time being. Like I said, we're going to brief the board for their direction. We will make further revisions to this. We will send it out for public review, and we will come back and continue this public hearing in January.
Thank you. No more comments? Without objection, we remain open. Next up,
Moving on.
CTA 0123. Public hearing is hereby open. An amendment to change the zoning definition of gun and archery range and conditions for approval. We have a number of people who would like to testify. Scott, take it away.
Okay, we'll skim through parts of this. You have, you've seen the history of where the gun club has been and where they wish to go. We have looked at the fact that there's very little definition so far. We have changed or suggested a change of the definition to add multi-day competitions and the supporting activities that would go along with those. Part of that was a set of conditions. These first 5 have been pretty constant since the first revision, so I won't spend a lot of time on those. And then the second part was this was the amendment first adopted and then that you reconsidered at your last meeting, which had half-mile and 1-mile boundaries. A further revision suggested only a half-mile if it had some sort of mitigating effects, but a 2-mile if it had nothing. And then the rest of those had stayed the same. And so what that ended up looking like is generally this map, and what's in the very, you can sort of see the blue is a half-mile, the yellow is a 1 mile from municipalities, the others are boundaries from state parks and others. And the red hatched area are areas that are already zoned that the club would not be permitted in under today's code. There was distinction there was a lot of discussion about this last time. The gun club submitted a legal opinion from their counsel at the request of our counsel. Our legal counsel wants again to take testimony today, but continue this so that they can study that legal opinion and bring in a decision back to you probably after the first of the year. But we're still here to take further testimony today. And Mr. Chairman, that's all I have.
Okay, thank you, Scott. No particular order. Dwight, do you want to go first or do you want to go last? Okay. And Tom, you're the gun club advocate, right?
Yeah.
Did you want to go first or do you want to go for the other? Okay, gotcha, okay. And Todd, who's Todd? Yeah, you want to go?
Thank you. For the record, my name is Todd Hume. I'm an attorney in private practice with Witherspoon, Brassich, McPhee. I want to comment on the 1 mile buffer that's being proposed in a couple of ways. I submitted, that Scott mentioned a minute ago, I submitted a letter into the record on this. I want to touch a couple things, and then I've got a policy point I think that bears remarks. First of all, the 1 mile buffer, at least as I view the record, is unsupported by the record, right? So it's an arbitrary 1 mile. Why not 2 miles? Why not half a mile? We just got done talking in the last item about buffer sizes and how those are indexed to sort of best practices. We don't have anything in the record suggesting that 1 mile is appropriate here. I cited a couple of cases. I know the legal counsel will study those, so we don't need to get into that here. But any proposed mitigation has to be directly related to the impacts that are identified in the record. Your record just hasn't been developed that way. So I would suggest to you that a 1 mile buffer is simply not sustainable. On the contrary, you've got a conditional use permit process. Those are site-specific analysis. At that time, that's when noise mitigation should be analyzed. 2, you're going to create an internal inconsistency. Your code already has a provision adopted from the WACs that exempts gun clubs from the discharge noise created by discharge of firearms. So on the one hand, you're going to have this provision in your noise ordinance that says it's an exception from noises. On the other hand, you're going to have a provision that says we are going to regulate noise from gun clubs with a 1 mile buffer. I think that's appealable to the Growth Management Hearing Board, and I think the board ends up sending that back to the county. I've heard comments about nuisances. Well, aren't these really a nuisance anyways? There was an email submitted into the record on this, citing a couple of cases. There's no doubt that there are cases out there against all kinds of uses, and that a legally existing use can become a nuisance. I mean, Morin versus Johnson, downtown Spokane in the 50s was a tire capping plant. The smell from that plant produced a nuisance. Riblet, some of you are familiar with the Riblet case in the cement factory across the river. That was a legally operating cement factory, produced a nuisance. We can't presuppose that gun clubs are going to create a nuisance. And even if you had a mile buffer, it doesn't keep somebody from bringing a nuisance claim. One item of public policy I want to hit in the last 30 seconds here. You've essentially turned your rural lands on its head. Rural lands are intended to facilitate farming, mining, forestry, lots of uses. And for decades and decades, it was intended to gun clubs. Now, in favor of residential use, we've always allowed residential use, but in favor of residential use, you've essentially created a protection for those uses to the detriment of the uses that the zone is intended to allow. That was quick. Thank you.
I'd like to, could we consider this speaker as an applicant and limit that? I mean, I'm really curious about what he's got to say.
Sure, be happy to.
Another 3 minutes.
Okay. If you go in and read what the rural lands are intended to do, and the idea that the GMA requires you to protect rural lands, ag lands, we just got done talking about that in the last item, protect rural lands and ag lands from urban encroachment, right? But what this does is it says we're going to ignore that. We're actually going to cherry pick some of these uses, and we're going to protect the residential uses that are there. The residential uses have always been there. They're incidental. People want to live where the farming is, right? But that was never the intention of the zone. I guess the other point on that policy piece is that there are no other uses that I can find in the county's code that are pinpointed like a gun club might be for protection against other uses. We do set buffers around things we're trying to preserve, right? We try to preserve wetlands. There's all kinds of analysis on what does the wetland look like? What's the quality of the wetland? How do we provide an associated buffer for the wetland? What protection are we trying to create? There's buffers around, we just talked about it in the last item. There's buffers around things of moral turpitude, pornography shops, cannabis, alcohol sales, right? You got to be within 1,000 feet of, you can't be within 1,000 feet of a school, et cetera. But here you're singling out the use, giving it a 1 mile buffer without anything in the record suggesting that that is adequate or indexed to the actual impact that you're going to create. It would be unlike anything else you have in your code. And there's also nothing in your code that would otherwise insulate cities. I'm not sure what that means. The idea that an entire city with all its multiple uses, right? So a city has residential use, city has commercial use, city has industrial use. I mean, would this say that you'd have to be a mile from the industrial complex in the valley? Are we trying to protect noise from the industrial complex in the valley? It's a city. So singling out an entire city and all of its individual uses also seems arbitrary. So I don't think this is well thought out. I think it deserves to be analyzed in the conditional use permit process, where you could have acousticians based on the actual property itself, the surrounding topography, figure out where that noise goes and what the appropriate mitigation would be. But to slap a 1 mile prohibition on every gun club would offend the GMA because it offends your zoning and is arbitrary and frankly unlawful.
Thank you. Connie, Kata?
Well, that was kind of a tough act to follow, but I would have to say, and I'm Connie Kata, by the way, to say that a gun club is similar to ag lands is just, to me, not making any sense at all, because we all know that a gun club is going to be noisy. So anyway, I do appreciate the committee's concern on trying to get this right. The revision of October 2nd was very encouraging. I'm a board member for the Medical Lake Cemetery, and although I believe the gun club when they say they have given up developing on the Thorpe Road property, I have concerns for other cemeteries and schools that will be faced with a situation like we had, where we found ourselves in court for 5 years. I would hope to see that the revised amendment strong enough that a hearing examiner can't bypass the 2 mile boundary. Our experience with the hearing examiner has not been positive. Thank you.
Thank you. Michael Chambers, please. Welcome back.
Michael Chambers, 33424 South Houck, Cheney, Washington. My question this morning is one of understanding, and that is that when I read through the revisions of 10.2 and I look at the map that was presented as far as the 1 mile setback, the revision of 10.2 has 2 miles. It also has in that revision, it says boundary requirements may be reduced to a distance no less than 0.5 miles, pending approved sound suppression measures and best practice for safety standards determined by the hearing examiner are met. Can I ask where that information is and how they come to that conclusion of what is best practice and how that actually plays out?
Best practices in terms of staff research have involved looking at things like the United States Sports Shooting Association, the NRA, others who run gun ranges, and how they generally operate, what their range safety officers do to work on that. It's a starting point of practices that we can defend because they're in common use in other places.
So again, I guess then I would go back to, are we talking about the map as the guideline? We talking about the ZTA 0123 revised 10.2, or are we talking about some other information I read there? I'm just confused, and I would like to have a better understanding, at least presented in the data online. So when I read it, I know what I'm reading. So
The way the process will work at the end of this is there would be an adjustment or a revision, an amendment to the Spokane County Code as has been presented to you. It would change both the definition in the definition section, and then it would change specifically in the zones that this would be allowed, what the conditions are for a conditional use permit. That process goes before a hearing examiner. The map that we put up was simply illustrative that says, based on the discussion points that have come before you, here's what that area would look like. There will not be an official map. Each one would be decided on a case-by-case basis using those rules. So if there is a setback in there, that would be considered at the time and place of a piece of property petitioning for a conditional use permit. And like, as I mentioned before, Mr. Hume was here. One of the reasons we're asking you to continue this further is for our legal counsel to study the arguments being presented by Mr. Hume and consider how to bring that back to you that is both legally sound and provides a public policy benefit for both, ideally, again, the balance between the gun club as a recreational use and nearby property owners who are concerned about being adjacent to it. So there's a lot yet to go.
Okay, thanks.
Thank
Thanks for
you.
your time.
Anthony Whitehead, please. Oh, good. Could we, after Anthony, we'll do that person, okay?
I'm Anthony Whitehead. I live at 22022 West Thorpe Road, Medic Lake, Washington, 99022. First, I want to start out, Mr. Rayner, didn't you recuse yourself from this?
Yes.
So why are you asking questions? Do you know?
Find my line out. Oh, right.
As I heard it, he didn't ask a question. He just asked if the speaker's time could be extended,
No,
which
he
is the
says,
chairman.
I'd like to hear more. You would like to hear more. You recused yourself. So I'd like to start by talking about the sound. There are many situations where there are limits, there are distances around things. For example, the joint land use study around Fairchild, there's a huge border around Fairchild related based in the sound. And it's related to the impact of that sound to the people that live there or live close by. So there's precedence. There's a reason why people wear ear protection when they shoot. And there are things that we should protect, like a cemetery, that we shouldn't park a gun range 50 feet across a road. That's reasonable. I also want to talk about some comments at the September 26th workshop that was postponed from the president of the gun club. He had mentioned Issaquah High School and that, they have a gun range very close to it, like within a third of the mile. High school, middle school, it's actually is what it is. And anyway, a couple things that I'd like to point out about it is that the high school was established on that site in 1901. The gun range came in 1920. This was before planning guidelines went into effect. So this is a grandfather situation. I think the Spokane Gun Club wants the same kind of situation with being grandfathered. They want to be able to take everything that they did on that site and move it based on being established way, way back before the planning guidelines went into place in about 1990, 92. Also want to point out something about the gun club. They are not good stewards of the property. Central Valley has paid nearly $3 million to clean up that site. There was more than lead, there was arsenic. And that's, so these best management practices that are going into effect, there's no police. There's nobody going and checking them out all the time. It's up to them. All that can happen is if someone finds out, citizens or the government can sue. So they're not good stewards, they're not good neighbors.
Thank you very much. We're down to the last two. Who would like to go first? Tom? Neil?
Somebody online?
Oh, I'm sorry. Let's do the online one first. Thanks. Appreciate that. Let's do the online portion first. Who, John? John Ogden, open the mic, please.
Okay, is it open?
It is. Thank
Okay,
you.
good. I usually don't do that well with Zoom, so I must have got lucky.
You're doing great.
Okay. Yeah, my name is John Ogden. I live on 2311 South Reeth Lane, which is near where this proposed gun club would be. I just have several objections to them coming in there. Obviously, the first is noise. You know, we live in the country partly because having some peace and quiet. And that right now is being threatened. I know I have guns. I know how loud a shotgun is. And you take 20 or 30 of those things shooting, and they can do it all day long. There would be no peace and quiet. The gun club says, oh, it won't be that noisy. Are you kidding me? And this, I don't think this gun range belongs in an area surrounded by houses. They belong more out in a rural area with no homes around, no cemeteries around. But for some reason, they just keep pushing for this site that's surrounded by homes. I mean, and then as far as cemeteries, could you imagine trying to hold a graveside service with all this shooting across the road? And also, you know, besides a medical cemetery, the veteran cemetery would be able to hear all that noise, and they do many services a day. I really agree that there needs to be a large buffer zone. I'm not sure what it's looked at right now. I've heard 1 mile, I've heard 2 mile. But I think that this would solve these problems, both for the people around where the range would be, and for these cemeteries. I mean, could you imagine holding a graveside service across the street, or even at the veteran cemetery? How could you do that? I mean, you couldn't with the noise. Oh, and lastly, I wanted to say that one of the ladies that is in the neighborhood and has done a lot of work on this, she went to the gun club's website, and it had this comment. It said, the Planning Commission gives us anything we ask for. That's on there. So I hope that we can stick with the large buffer zone. So thank you.
Let's do it.
Hello?
Sharon, can we put you right behind Mr. Nihal? He has a doctor's appointment. Will you just
I'm
stay with us,
totally
please?
fine. You bet. You bet.
Thank you. Thank you so much.
Welcome.
Tom, go ahead.
Hi, I'm Tom Nihill, 13124 South Upper Meadow Lane, Spokane 99224. And I am president of the Spokane Gun Club. I brought up the whole issue of the Issaquah thing, not because they're there, but because they are close to each other. That was one thing. We are not, as I've said multiple times, we are not against a buffer, but we are against a totally ridiculous buffer, whether it's a mile or 2 miles. What we want to have is the capability to have a club, and we want to have it in Spokane County. And Scott, I didn't see anything on your map. I saw the 1 mile, but I didn't see if you'd put that out there with 2 miles, how that would impact us. It's a major gotcha.
Both, both of those boundaries are up there. We can put the map back up if necessary.
I thought you said the red was a 1 mile. Anyway, that's
Yes, I'm sorry, there's not a 2 mile.
right. And so the 2 mile would have a major, even a more impact, greater impact on us. The second thing about that is we are not wanting to be in the current property we have. Medical Lake Cemetery can forget it. We are not going to do it. The half-mile buffer that they put would take away all of the property we have other than in the northeast corner of that property, and there's not enough ground in there to build a gun club. So it does not work. And that's it. Finally, the last thing I'll say is I dispute the cleanup of the property that we used to have. We have $1 million set aside for the school district for remediation. They have not asked for any money. As a matter of fact, they're talking right now that what they're going to do is for part of it. And we've got that $1 million. They haven't asked for anything in 5 years. So I take issue with anything on remediation. I know they did a lot of work on site prep for the high school. And they're talking about adding a middle school and an elementary school on that property. But so I don't think they're correct on that. Anyway, that's all I had to say. Let's get this thing done. And what I'm hearing is it's going to be next year now. Okay.
Thank you.
Thank you.
Thanks for your patience. Let's get back to our screen here. Sharon,
Hey,
you're on mute. Go ahead. Thank you for being patient.
good morning. Thanks you guys for taking this so seriously. Sharon Whitehead for the record. I think it is a delicate balance. I am not an attorney. I appreciate that that's being looked at. But if that is the case, I guess, the world's getting busier, more people in the county. It isn't what it used to be in terms of all kinds of open land and there needs to be a balance between residents and people who want to have gun clubs. And there should be some requirement that there be an engagement between the two. I mean, when you're talking about, and we've heard it, people wanting to shoot 7 days a week, all day, the ability to do that. And you think about the number of residents in Spokane and the economic viability of people who are moving to Spokane. I do think this is a difficult thing and it needs to be thoughtful. Having a buffer of half a mile, whatever it is, I think is reasonable. And if that means the code has to now accept that Spokane is bigger and more populated, then that's the case. I hope there's a place for the Spokane Gun Club somewhere in Spokane County. But as someone said before in previous meetings, it's location, location, location. The challenge, the property still hasn't been put up for sale, the one in question. It's nice to hear again that it's not intended to be used. That's great. At the end of the day, however, I do think the balance between the humans and their culture and a gun club and its culture has to be achieved. Everything else in the code is really about giving gun clubs more than they've ever had before. It doesn't balance out with what people around them want to do. When you're somewhere and people make a choice to move close, that's on them. But if you want to put it in the middle of other people's culture, that's always where the challenge is going to be. So I appreciate the 1 mile radius. I think that's responsible. I think that's humane and balances the culture. And I hope it continues that way. Thank you.
Thank you. Anybody else? Anyone else online? Dwight? You are up, sir.
I'll be brief. Dwight Hume here on behalf of the Gun Club. I think we're down to the legal argument and weighing the rights to impose language that, in our opinion, is standardized language, not realistic to address the specifics of a particular site. I've said before, once a conditional use permit application is submitted, it's for a specific property. It goes with advertising of the surroundings. It goes to a hearing to be determined by the hearing examiner and thereafter by the courts. It's impossible to say what the noise impacts will be, albeit the wax exemption of that right to the noise. So here we are now, down to the point of the county's legal input and ours legal input on whether or not this kind of language needs to be put into the Spokane County zoning code. I'll leave it at that. I'm sorry we have to wait till the first of the year for an answer. You guys last time requested that the legal counsel be present today and isn't. I'm disappointed in that inability to be that responsible. Thank you.
Thank you, Dwight. Scott?
Mr. Chairman, I did give the clear impression that we would defer this into 2025. As we start looking at the legal argument presented to us by our counsel and get together and talk about that, there's every possibility that some recommendation or solution could come before you before the end of the year. Unlike our comprehensive plan amendments, the zoning text amendments can be taken up by the commission and the board at any time. So if we are able to make progress on that in the ensuing weeks, this could come back quicker. We just recognized, like everything, that our board takes a holiday break, they take a Christmas break, and it's sometimes difficult to commit to making progress during the holiday season. But if we can make progress, we will be back to you.
Commissioners? Comments? Did we miss anybody in the audience? We have somebody on the line?
Yeah, Mr. Chairman, it's me, Logan Camporiale. Sorry to be late to the meeting. I may have missed this because, again, sorry to be late. But did legal counsel prepare anything, or are we still waiting for that? It sounds like we're still waiting for that. Is that correct? I didn't see anything in our packet, but maybe there's something in print.
No, we're still working on that, and nothing has been ready for sharing yet.
Sweet. Thank you very much. Appreciate it.
Thank you, Logan. I don't want to miss anybody. Everyone got to speak that wanted to speak? Commissioners, do we have comments? Without objection, we'll keep the public hearing open.
Thank you.
Should we,
Mr. Chairman?
we pause for a 10-minute recess, or should we?
Your discussion, of course.
We just have, yeah, let's do that. 10-minute recess, so ordered. Thank you. Taking of CTA, this is a workshop, ZTA 03-24, events facilities allowed in rural Spokane County. Mr. Chesney.
Thank you, Mr. Chairman. We've got a few slides for a reminder of where we're going. Let me go through the first part of this because it's things you've already seen. And so this is where we started. The current rules for event center in the small tract ag sections have those codes. These were some proposed changes to allow this as a temporary use in the rural traditional zones. We talked about some of those similar seasonal issues, time of day issues that were there. We also talked about whether it would be in this kind of case, and some of this we've already amended, but I wanted to throw it up just as a reminder, whether it becomes a temporary use in the rural traditional zone as it started out. We also explored the conditional use process, a CUP, that would allow it potentially in a broader sense of rural zones. And that part is going on. This was the example we shared earlier. The map on the left shows the small tract ag zoned lands. The map on the right shows the rural traditional. So if that is ultimately pursued, there's a broad scope of lands that would be eligible for this property. Here's where we hit our snag last time and where we still don't have clarity. This is an excerpt from the state Supreme Court decision that was handed out just before your last meeting, and we're studying this. And it's you can see the similarities, wineries, breweries, and distillers in land designated as ag and rural under the King County Comprehensive Plan. And then they talk about the GMA in particular. And then the hearings board determined that the county did not comply with SEPA and the GMA in making this zoning change to do that. The appeals court reversed the Growth Management Hearings Board, and subsequently the Supreme Court reversed the appeals court and reinstated the board's order. What we have to do in the foreseeable future is look at, essentially, as we said last time, the basic part of this is King County was adding a use that would in fact be built on ag lands, therefore taking those ag lands out of production, or at least denigrating the quality of ag use in those lands. And these are essentially the wineries along the river in the Woodinville areas where this was taking place. Very different approach than the Palouse and our large tract ag or even the rural traditional. But we have to be careful of now understanding what this decision means before we can put a position in front of you that is legally sound. And so this is another one that we're going to be asking you to simply continue the hearing, and we'll be briefing the board on the 29th when we bring these before them and asking them to continue it as well. Our commitment is to understand this in a way that we can get something back before you by the end of the year or shortly after the first of the year, so that the folks that are in this position will have clarity going into 2025 on how to be able to do this. What I see as the initial outcome is probably takes away the conditional use permit part of this, because that was presumed to be used in ag lands as well as rural lands. If we go back to our original premise of a use in rural traditional lands, and those rural traditional lands, while they're zoned rural traditional and therefore not ag, the only real constraint we might have is if it's a rural traditional zoning on top of prime ag lands for some reason. But that would be a nuance that we would have to consider on a case-by-case basis. So the distinction is because of this. We were comfortable moving this forward, still are comfortable moving this forward. But those of you that have been here long enough to understand what the county went through in the early teens, if we were to push this very quickly, FutureWise, which brought this case before King County, would obviously do the same to us, and we would be right back in litigation for years to try to solve it. So our part is let's figure out what we can do legally up front and then go in that fashion. And so we'll be looking at the case. We'll be looking at it from a legal perspective. We'll also be talking directly with FutureWise to say, here's what we're trying to do. You know, what objections do you have? And that way we'll be able to bring something back to you that we can defend, and will be, I think, good policy for the vendors and people that want to do this, as well as residents of the county that want to take advantage of it. And there's no question there's a value of this. If anybody went to any of the Harvest Festival events over the last couple of weekends on Green Bluff and saw the traffic, there's still a lot of demand for what's going on in some of those small wineries and beer halls and other things that are up there. So we're confident there is a solution, but we're not ready to bring it forward today.
I've got a question. When this was first brought up to us in the last few meetings, the question came up is what is the application of this court ruling on existing, I mean, we have charts of permitted uses in different zoning. And it seemed to me that half of those permitted uses in agricultural zoning could be shot down by this court ruling. And do we have a problem with pre-existing approvals, or where does this thing end?
No, almost certainly not. I mean, those fall into the well-accepted case or category of prior non-conforming use. Generally, if that would be the case, what that means is you can't expand them. You can replace them, you can continue to operate them, but you can't make them bigger, or, you know, in the planning language, you can't make them more non-conforming than they already are. We don't see this having that kind of precedent value. This seems to be very narrowly focused on, can you take lands out of ag and do something else with them? That was the FutureWise content, is it was inconsistent with GMA because it removed ag lands, and ag lands are protected under the Growth Management Act. So we think that's the basis of this decision, but it is, you know, dozens of pages, and you have to parse through every line to see if we're missing something.
I had a question of clarity. The individuals who had made a request for such changes or revisions to the guidelines, are they kept informed of the actions and where you're at right now? Again, education is the most important part of this whole thing, of understanding it and moving forward.
Right. If we have email addresses, we can send things to them. Typically, we post this on our web, and when somebody either sends a comment or something, they click the button that says, I want to be notified if something changes. Mr. Chairman, I think that's all I've got. I would welcome opening a public hearing for other public comments.
Public comment workshop. Trish, Easton, you want to come to the podium?
Thank you. Hello, I'm Trish Eason. Do I need to say my address?
No, you don't need to do that anymore.
Okay, perfect. Spoke many times on this and very much understand kind of where we're at. Appreciate your support and finding a way forward. Another consideration, and my venue is, my business is I'm a commercial greenhouse nursery that naturally does weddings and events because we have the space and whatnot to do so. Another thought would be an update to the definition of greenhouse commercial and have something similar to a land use category that allows the operation of a greenhouse or nursery for the cultivation and sale of plants, flowers, and related retail products. This category may also permit the hosting of educational, social, or recreational events related to gardening, such as workshops and classes. Weddings and social events are permitted as an accessory use, subject to the availability of space and on-site parking, so long as accessory business use revenues are secondary to primary business. All events are required to comply with the noise ordinance of which it is located. So in the, support of allowing different revenue streams, which in all honesty, an outdoor nursery in Spokane, Washington has a 6-month season. There's nothing around that. When my husband and I first bought this property, we were contacted by, county and told very specifically that if it's not written in the definition, you can't do it. Don't think of selling candles. Don't think of doing some of these other things. And we do sell non-green good, potteries, part of that. Any sort of, retail that's in line with nurseries is essential to our business and our bottom line, and our growth and everything. Taxes we're on city water. Our water bill is pretty astronomical. And so, to exercise and utilize our property for the community would be very, very helpful. So even an update to greenhouse commercial might be, that accessory use option might be helpful as well. So thank you.
Thank you. Greg Miley, Jody, or who wants to go next?
Greg Miley, 15015 South Stents Road.
the comments that Trish made, of course, you've heard, and the language that she was talking about are great for her venue and what they're doing, and it may be a better way to do it. I was surprised to learn that the conditional use permit that we've been talking about may not work because of this court case. And in our particular situation, our 10-acre plot is still being used for agriculture. We still produce wheat, barley, dry peas, whatever I decide that I want to farm it with, as our adjacent neighbors do as well. But there's a part of our ground that was non-farmable. And that's the part where we located our house. We located our parking for our venue. And it fits well for what we were doing because we didn't disrupt our agriculture. We have both. And that's what makes it a very unique setting. We have a video that we wanted to show you that hasn't been shown yet because we can't find it. But we submitted a video so you could see how the layout was, at least for us, with our home, our grounds, and then moving on into agriculture and look at the mountains, et cetera, and why people came to us and stopped at our home and said, we would like to get married in your front yard or your backyard. Could we do that? And that's how we got the idea of having a wedding venue. Palouse Ridge Events was formed because the public came to us. Logan asked us to talk to, Commissioner Logan asked us to find from our neighbors what they thought. And we have submitted testimony from them, written testimony as you requested it, endorsing what we're doing. So we're starting our season. We just ended, if you will, the active season. Now we're busy in the season of booking. And the sooner we can get resolution and how we move forward and allowing us to move forward with no exceptions would be great. So thank you.
Thank you, sir. Anybody online would like to speak? Oh. Do we cover everybody in the audience? Commissioners? We have, come down, please. Thanks, Pete.
Sorry, I didn't get this one in time. My name is Rebecca Schmidlkofer. My husband and I are the new owners of the Rosarium Garden Center located in West Spokane.
I didn't catch that.
The Rosarium Garden Center located in West Spokane up on Paradise Prairie. And so I would just like to, speak a little bit in support of what Trish has said. Newer to this industry, but the importance of the proposed change to, and I'm going to get the wording wrong, but the proposed change that Trish mentioned, we're in support of for that secondary revenue stream, that it's important with events and that sort of thing. So I wanted to just speak and get my name on the record for that. Thank you.
Thank you. Thank you, Pete. I'm going to get her in a minute. Yeah. Anybody else? You want to talk? Go ahead.
Just to help me out, what is your address or look, you just said the west side.
The Rosarium is a nursery on. Yeah.
Okay, thank you.
Other comments? Thank you for your participation. Next order of business is the approval of a variety of minutes.
4 sets.
Now-
August 15th, August 29th, September 12th, September.
I see that now. This doesn't go back to February, does it? No, just kidding. Some of these are on letterhead and some are not. Does that make it any less official?
No, the draft minutes generally don't go on letterhead. We jumped ahead on some of them in anticipation that you might approve them. They will be put on letterhead once they're official.
Okay, so the first one is, did you say the 9th?
August 15th is the oldest.
August the 15th, correct?
Yes.
Let's take these one at a time, if we don't mind. So the question before you is approval of the minutes of August the 15th, 2024. They were in front of you. Hopefully you've had a time to review those and note any errors or omissions or adjustments that need to be made. Logan, do you have those minutes?
It looks like those are the only ones I'm missing. I think that the rest of them were in the packet, but I don't see the 15th. I only have the 29th, so I will abstain for the 15th. But I have the rest of it.
Oh, okay, I see that. Okay, via Zoom. Okay. Any questions? Pardon me?
I'll abstain because I was not there.
You're going to abstain. Okay. Do we have a motion to adopt these minutes for August the 15th, 2024? Second? Second. By Lonnie Edwards. No discussion on that motion. All those in favor, well, all those in favor signify by saying aye.
Aye.
All opposed? Thank you. Those minutes are adopted and Mr. Wayne Brokaw has abstained.
I have
You got all that, Susan? Thank you. Thank you.
point of clarity of
Yes.
the spelling of my name.
Yeah, mine's with the PH, but that's okay.
Mine doesn't have an E on it.
But Stephen is a PH. Well, some of them are right, but so I don't beat yourself up. Okay.
On mine is HAA, not ASSAA. NOE.
Oh, yeah, you're right. Well, then
You're not the only one.
Then you can't vote, Clyde, because your name is in. We asked for additions and well, here, after we voted on it, and now you ask for changes. Yeah, right. All right, those are done. The next, the approval of the minutes for August the 29th, 2024. Everybody's had a chance to look at those, aside for,
Move for approval.
well, how come my name's not on here?
You weren't here.
I thought it was the one in September. I wasn't here.
29th, you weren't here.
I see that.
And my name is misspelled, and I'll bring it up now.
Well, I'm going to turn this over to Pete. So Pete, you need to, since you ran the meeting, this is your ball of wax. So I'll obviously be, I'm saying that you weren't there either.
We have a motion for approval. I would have motion to approve. Second.
Second.
I'll abstain again. All those in favor of the motion signify by saying aye.
Aye.
Opposed? Abstained?
All right.
Shane. You can,
Motion approved.
yeah, you can,
Back to you, sir.
you can send that back to me. Before us now are the minutes of the Spokane County Planning Commission dated September 12th, 2024. My name needs to be corrected with the PH. Mr. Hazy needs to have a correction of his name.
Thank you, Mr. Chairman.
You're welcome. Any comments, any corrections other than those? If not, the chair will entertain a motion to adopt these minutes.
Motion to
I
adopt.
review.
Thank you.
Second.
I heard Melissa first. Oh, second from Logan. Okay, great. Thank you. All those in favor of adoption of the minutes of December the 12th signify by saying aye.
Aye.
All opposed, nay. Those minutes are hereby adopted.
Wayne abstained.
Wayne abstained. Write that for the record. All right. And now before you are the Spokane County Planning Commission minutes of September the 26th. My name is spelled right. Clyde's name is not spelled right.
I will abstain. I wasn't here.
And you were not here, so there's an abstention right there. Any discussion, any further changes to the content of these minutes? If not, the chair will entertain a motion to adopt these minutes.
Adopted.
Adopted. Thank you. A second by Wayne. All those in favor of adopting these minutes signify by saying aye. Aye. Logan, were you there? Logan, didn't hear from you. Logan?
Aye. Sorry. I tried to unmute, but it was fighting me.
You can't run, Logan. We know where you are. Okay. Hereby adopted. Thank you very much. Is that good all? Thank you, Spokane County, for getting that information to us, and we appreciate that. Staff report? It's not on here, but the next meeting is November the 14th, but we always customarily have this. Oh, before that, I want to ask this person.
Oh, okay.
Suzanne Saval. Let me just recite that we have a time and a place for people who want to address the commission at the very beginning of the agenda. That's not on this agenda, which is appears what you want to do here. But because I have a propensity as the chair to be as inclusive as possible, I would like for you to come down here and state why you're here, and you have 3 minutes. Our pleasure.
Hello, I'm Suzanne Saval. I own a home on 6412 North Jensen Road in next to Bigelow Gulch on Jensen Road. First of all, I want to thank you for your hard work. I know you're making really difficult decisions, and I'm hoping my decision will be easier for you in the future. My goal here is just to show my continued interest in requesting a change in the UGA for my property. I started this work in March, and I have additional documents in my file. I really am just requesting that I can build a home, a retirement home on the back of my 5-acre property. And so that would involve rezoning. The amendment would not be detrimental to the community. I have signatures from all my neighbors stating that they approve this UGA change. I have a letter from Pasadena Park Irrigation saying that it's not a problem for me to get water. I've talked to I also just recently had a survey that's going to be placed in my file November 3rd. So I'm just asking, is there an opportunity for consideration for amendments to UGAs in 2025? I know that I missed this in 2024.
There's nothing in 2025 because we're updating the 2026 plan. And so the UGA discussion will start with the steering committee in January. They will probably see some draft maps for study by March or May, and they would presumably at a July meeting might make a recommendation to the county board for 2026. So the schedule is through 2025. But it won't, and unfortunately, the recommendation for the UGA would be just that for the time
I gave it to you.
adopted in June of 26.
Those are all the wrong answers. I know, so there's nothing that I can, I mean, I just.
Aside from comprehensive plan amendments, which any municipality can adopt annually, once a year, they can do these annually. The urban growth area boundary cannot be changed except in a periodic update for 5-year cycles, except for certain swaps that can take place on an annual basis. But Spokane County is prohibited from doing that for 2 reasons. One relates to a settlement agreement, past activity that we're still under and we're working our way out of. And the second is, while the legislature approved the swapping language, they also said it cannot change the capacity of the UGA. It can't change the acreage, and it also can't change the development capacity. So that would mean you said you had a 5-acre parcel. A 5-acre parcel in the UGA that is ready for development would have to come out and yours would go in. So you'd literally have to swap with another property owner to do that.
Which, I mean, that happened with the agricultural building just down the road from my place in Nom Nom. So that's already happened. So could that be the swap?
May I ask a question? Do you, you just have 5 acres total or a total of 10?
Total of 5.
Is it possible for like an additional dwelling unit, like on the property for like, that's under 800 square feet or something to build a retirement home?
ADUs are currently not allowed in rural zones.
Okay.
There was a bill in the legislature to allow that this last year. FutureWise successfully allowed him to get it failed. And the claim was it would double the densities in rural areas and put undue strain on water supplies.
Even though Pasadena Park said it wouldn't be?
That was a state legislative piece that failed, that would have allowed for at least an ADU, but you know, that wouldn't be a full-blown house. It would be 800 square feet. But yeah, we are constrained in the urban growth area until 26,
Thank you for your time.
but we know where you are.
Thank you. Staff report? You're not on the agenda, but the chair will allow, we want to hear what you have to say. I think.
Very generous. Thank you. This is the completion of most of your work plan for 24. Thank you all for your patience, your effort, your questions, your diligence. We've gone through our comp plan amendments. We've now gone through the zoning text amendments as much as we can this year. And so we're done with our statutory responsibilities for 24. Accordingly, at our November meeting, we're going to jump deeply into the comprehensive plan 2026. We will have staff up here talking about what work they've been doing this past year on the various GMA elements, getting into some detail of those, setting the table for some questions about that. And then we will also talk a little bit about where we're going with our consulting teams in the idea of placemaking, scenario building, and some of the things that we've heard from our public and others. And then we will also finally, or add to that, go over kind of briefly what the environmental impact assessment, which is a kind of a third leg to our stool for the process. One is the comprehensive plan update itself. The second is the new climate and resiliency element added to GMA in the past legislative session a year ago. And then the overall part, the environmental impact statement that the county relies on dates back to 2001. And it desperately needs to be updated. And so we're doing a full environmental impact assessment and statement as a parallel process. That will parallel the scenario building idea because it looks at alternatives. One is traditionally a do nothing alternative, and then there'll be 2 or 3 or maybe 4 total alternatives that look at different kinds of development scenarios. And then each one of those will be studied for environmental impacts. And those will be presented to you as, here are the impacts. Here's what perhaps mitigations are necessary to do those. So we will roll up our sleeves in November and have a robust discussion of the comprehensive plan process and where we are to date. Our team has put in a huge amount of effort, and there's a lot to share.
Got a question. Will properties being considered for inclusion in the UGA be considered under the maximum density that could be possible under their request, or are they capable of submitting a lesser request? I don't know if that makes sense, but
Sure, it does.
The state laws has, and like what's happened in the city and where we are in the county, people that might want to come in with single family housing by state law now are up to like 4 units per acre or whatever per lot.
Right.
How does somebody come in, and we have people that want single family housing? How do we accommodate them without being blasted with 4 or 5 or 10 times the density that they're actually going to deal with?
In considering expanding the urban growth area, again, we are prohibited from taking applications to do that.
Okay.
We have told interested property owners, send us a letter of interest so we know who you are, tell us about your parcel, and then we've got those in a file. So that'll be part of a study effort that happens, kind of late this year, early next year. Your question, though, is a good one because the county increased its single family or LDR, low density residential zone from 2 to 6 units an acre up to 2 to 8 units an acre in 2020, and up to 10 units an acre if some of those are duplexes. And that alone added, almost 30 or 40% more density to every single family lot that's already platted. and new ones that can go forward. The state also in GMA subsequently said communities must make allowances to allow for duplexes, triplexes, and fourplexes in traditional single-family neighborhoods. And so again, there's a 4 times density factor on existing lots. The city itself was even more aggressive in doing that. And anybody that drives around the city has probably seen infill lots that are in a traditional single-family detached neighborhoods are all of a sudden sprouting up 4 townhomes on a previous single-family lot. So developers are taking advantage of this on a small scale. What it means when we're conducting our land capacity analysis, which is what's left in the current UGA that was platted in or started in 2001, we have to consider that at these new densities. So if we had 100 acres, but that was going to be 200 homes, or let's say 400 homes, quarter-acre lots, we now have to say that's not a 400 capacity lot, that's a 1,600 acre capacity or 1,600 unit capacity. That's going to dramatically change the ability to add land to the urban growth area because we can accommodate more in what we already have. The market and a practical analysis of that means we also have to look almost at every individual parcel and say, is this a good candidate for more intense development or is it not? And then we have to be able to defend that to advocacy groups in the GMA, including the Growth Management Hearings Board. That also extends to considering lands coming into the UGA. They have to be considered at their maximum developable density under current zoning, which means if somebody wanted to bring in 100 acres, that would be allocated those 1,600 units. And if we only needed to grow by 1,500 units, you couldn't bring in the full 100 acres. So it's going to be a mathematical challenge. Then it'll be a geology challenge as we look at where the critical areas and things where you can't build on available land. And finally, geography itself, lands that are good candidates have to really be in the path of development, meaning they've got to be at or close to urban services. Water and sewer have to be available within a limited amount of time. And all of those layers come down to, here's what we need, here's how we have to grow. It's going to be a very different process than the county went through in 2016.
Mr. Chesney, does the planning department have a consultant on board for the environmental impact assessment? That's a lot of work.
Yes.
Good.
Yeah, we've reached agreement with two primary consulting firms, both of which have subsequent partner co-consultant firms on climate and resiliency. It's a group called Cascadia, who's also, they did help Commerce write the rules for the commerce and resilient elements. So they're well positioned to help us. They're also being used by the city of Spokane, and we took that into consideration so that we can better coordinate our efforts with the city itself. Our general planning consultants is a group called Facet. They have a Spokane office. They have several offices statewide. They're partnering with some other firms, including Makers on the west side, which I've worked with at the city. They are, I think, a great firm to help us with the placemaking and the rest of the GMA elements. And then a subset of Facet, their environmental group. They're an engineering and planning firm and an environmental firm. They will be overseeing the EIS.
And just a follow-up question, is there any intention or I guess intentionality about really sussing out the West Plains and the development level and pressure out there?
Absolutely. The comp plan amendment process that all of you have been through now for a few, or all of us have been through since I've been here, is a very fragmented process. It's a legal process. It's what's allowed by the GMA. It lends itself, though, to decisions that leave gaps. And notably, we're fixing one now by creating a park on the West Plains. Well, the park should have been there at some point before, or at least planned at the time some of this development was happening. We've heard many, many complaints from West Plains residents about stormwater and the challenges with stormwater out there. The county is working on a stormwater plan for part of that, $5.5 million. But the comp plan will look at the entire thing. And again, when you're talking about those urban services, stormwater is one of them. if you can't provide a stormwater solution for a series of parcels of land, those can't be in an urban growth area. And in fact, if they're in an urban growth area, they probably have to come out because you cannot serve them at urban densities without a detrimental impact. So there's no question the boundary of the urban growth area in the metro core is going to change. The question is it going to expand or is it just going to move around? But the West Plains is a classic case. It's going to be growing for more than the next 20 years. We really need to think about planning that deliberately now, and not just even in the 20-year planning horizon, but taking that 50-year look and creating urban reserve areas, creating areas that can logically expand past the GMA plan horizon.
Are we going to be in this process dealing with non-urban growth? And by that, I'm talking about rural.
Yes.
And because I've been spending a lot of time looking at properties on the West Plains and on the north side. When we adopted the GMA, we adopted urban reserve to protect future growth. There isn't any. I mean, it's all 10-acre parcels.
Yeah.
And what's left is being gobbled up very quickly. And I mean, if we don't do something about that, that is equitable to the current landowners and protects our children and grandchildren and have a place to grow, we're going to be skipping to Ritzville. I'm exaggerating, but not a lot.
Yeah, it's going to be because of these incremental policy changes, both locally and at the state level, we have to evaluate an old set of decisions under a new set of parameters. And that's it wasn't intended to be that way, but we simply have to look at it in that capacity. It also means, though, that areas like what we call the North Mead area, where North 40 is being built up on Highway 2 on Newport Highway, south of Daymount Spokane Road. That's an area that had its zoning carry over from pre-GMA days. And so it's developing at urban densities. The county has put sewer out there. Whitworth, for the most part, is their water district. We're going to draw an urban growth area boundary around that and create a place so it can grow in a more robust urban way. For example, the underlying comp plan on that is Lammert. It's the local area of more intense rural development, but it has the pre-GMA zoning, which is business, commercial, and single-family residential. And where that didn't translate, it's got the zoning called low LDAC, limited development area commercial. And what that means is you could build a 2,500 square foot fruit stand, but you can't build a C-store. You can't build anything more urban because it's not designated for that. We need to fix that part while we're also working on the West Plains, and then deal with the residential, for the most part, residential growth in the other UGA polygons. And as we'll talk about next month, that's where we want to start talking about how those can be planned for to be smaller, I don't say urban centers, but smaller, but neighborhoods. So it's not just 100 acres of quarter-acre lots, but it's 100 acres that's got amenities in the center, or walkable amenities or services or something like that. It's a different model, and we know we're going to have to talk to our builders and home builders about that and see how they believe it can be viable. But it's a direction we want to explore.
I have a question of clarity. I listened to your words of, we have a lot of work to do. And we use the date 2026, which is actually on the calendar. Last time I looked, looks like about 12 months in 2026. When is this going to take place? The first of 2026, middle? And do we have any ideas?
I think it's June 1, isn't it?
We're scheduled, we've already scheduled the board's agenda. June 30th, 2026 is the board's
June 30th.
Adoption date.
So all the other cities within the county will have to have the stuff, their information to you.
Yeah.
Prior to that.
Yes, we will get them all prior. They will all have to adopt by the same date, if not before. As far as we've seen from our colleagues, our planning colleagues, none of the cities and towns are planning a major overhaul of their plans. They're doing refinements for the most part. So it's a little less onerous than what the county is going through or plans to go through. The city is also updating its EIS, and they're devoting their entire commerce grant to just that EIS project, and they're doing the comp plan updates in-house. So, you know, they're going back to the centers and corners idea and trying to make it work, I guess is the best way to say that. So the point is, they can, in my estimation, and I'm not trying to make it sound like they don't have a lot of work to do too, because they're doing more of a refinement, it's very likely they can complete their work earlier than we can. But we will be coordinating with them throughout the process because when the county plan is ready, it will include all of the other plans, in some cases by reference, in some cases embedded within. So when we talk about, you know, urban Spokane County, it's going to start from downtown and work its way out. And we will be talking about the need for a vibrant downtown just as much as the city will be.
Seeing, are you finished?
I'm done.
Seeing no other business to come before this.
Logan had his hand up.
Oh, Logan's got his hand up. What do you need? Go ahead.
I was just gonna say, it looks like our next meeting is scheduled for November 14th. And I just wanted to let the commission know and staff know that I'm expecting or my wife is expecting a baby in the next couple of weeks. And so I may or may not be at the next couple of meetings as I learn how to be a dad. So just a heads up.
Thanks, Logan.
Congratulations.
Thank you.
Seeing no other business to come before this commission, the chair will entertain a motion to adjourn.
So moved.
So moved by P. Rayner, second by Melissa. All those in favor of adjournment signify by saying aye.
Aye.
By saying nay. We are hereby adjourned. It is 11:12. Thank you all. Thank you, staff.